Good evening, excuse me. Good evening, ladies and gentlemen, and welcome to the May 21st, 2025 Worcester Township Board of Supervisors business meeting. Would you please join me in saying the Pledge of Allegiance? My name is Rick DeLello. I'm the chairman of the board. To my left is Lou Betts, who's our vice chair. To my right is Steve Quigley, who is our third member. Over on the side table, we have Wendy McKenna from our solicitor's office and John Everts from our engineer's office. On the back table, we have Dustin Schreiber, who is works in our township office, who's going to be here tonight, and we have Dan Domino, who is our township manager. First and foremost, does anybody have any informational items for the board?
Mr. Chairman, this video is being recorded for broadcast.
Thank you, Dan. I actually have two quick informational items. The first is I want to notify the public that the Board of Supervisors attended the PSATS conference since our last meeting, which is the annual Township Supervisor Conference out in Hershey. We attend it every year. All three of us had the opportunity to attend. It's really a pretty good conference. I want to, after I'm done, if either board member wants to make any comments regarding the conference in general, they're happy to do so, but I wanted to share that. And the second item is that the annual audit for the township has been completed and is posted to the website. That took place since our last meeting. We will be having as we have in the past, a work session with the auditor where they can sort of describe the audit and answer some basic questions regarding the audit process. But the document itself is out on the website if anybody wants to go look at that information and share any comments that they may have. So do either one of you guys want to comment on PSATs?
Just to follow up to Rick's comment on the meeting we attended, two big issues. One is statewide zoning. A number of meetings and a lot of the conversation I had with people revolved around that, where each municipality has their own zoning laws and regulations. The state's proposing that we go to a statewide zoning where it's done there and we all have to follow. I equate that to our apartment complex over here. That was not our wish of the township, but the federal government, the state government, the county government told Worcester we didn't have enough apartments. So we had to do a study. The county came back and pick some sites out as to where it would be best suited. So a lot of times people are uninformed, misinformed as to how things get done, but we have to follow the rules and regulations set in, especially on these items for Harrisburg. The other issue is something we've dealt with the past 3 or 4 months is the public safety issue of ambulance service. That's become a big buzzword throughout the state of Pennsylvania. A lot of these ambulance companies are underfunded and going out of business. So Dan's been working with the local companies in the past few months. He has some meetings scheduled in the next few weeks with some others coming up, but that's a safety concern for the township, and it's something that we're working with. And as I said, it's an issue facing the rest of the state as well. So thank you, Mr. Chairman.
Thank you, Steve. Lou, you want to make any comments?
Fine, thank you.
He's good. Okay. So first item up on our agenda tonight is public comment. We do ask that you limit your public comment to 5 minutes. Does anybody have any public comment for the board this evening? Christine?
Christine Steer, excuse me, Baton Road. I just wanted to say a huge thank you to all our poll workers and student volunteers and volunteers. As you know, yesterday was our primary election. And I just want to say a big thank you to everyone that here in the township that sets up this building, you know, the folks at Worcester Elementary, Bethel Church, and Variety Club that, you know, put in the extra effort to make sure that we have a really good day. So I just wanted to make sure that those people get recognized. We had a really good day yesterday. The weather was beautiful, and we dodged a bullet because today is terrible. But it was a really good day. There was no reported problems that I'm aware of. And I just, again, wanted to say thank you to all those poll workers and students that came out and made the day run really well. So that's it.
Super. Thank you for your comments. Does anybody else wish to make public comment before the board tonight? In the back?
Jane Voss, Stony Creek Farms. I'm here about 1616 Whitehall, and I know there was a court hearing that I was not able to go to, I think on April 28th, and I believe that there have been a couple of inspections, and I just wanted to find out what's going on with that property.
Okay. So do you want to take that, Wendy? You want me to generalize what we did, and then you can fill in if there are any gaps to there? I'm happy to do. You want to do that, Dan?
Yeah.
Okay. Sure. Sounds good.
Yeah, so following that court hearing at the county, there was three dates that were agreed to as far as things that were going to have to happen. Within a week after that hearing, we were to inspect the site and reissue a zoning determination based off of what we were seeing at that moment. That has been done. They do have the ability to appeal that zoning determination to the zoning hearing board if they so choose. We have not gotten an appeal yet at this point. The big thing is by the 28th of this month, they are required to submit for full land development approval. And that will take care of all the dimensional things. So the first part of it was more of the use issue. The second part of it is more of the dimensional issue, meaning the impervious coverage, the structures, those types of things. It's been indicated that they're working on that land development submittal, so I expect to see that before that 28th deadline. And that's kind of where we're at.
And then what happens if they don't? Because it seems to me that there have been quite a few instances where,
So I can jump in there.
okay,
So Wendy, do me a favor, pull the microphone down so we can get you on the recording.
So at the hearing, we presented testimony for a good half the morning. And then we recessed, and the judge suggested that we talk to see if we could attempt to come to a tentative resolution. So that's essentially what happened. We put a tentative agreement on the record saying that these things have to happen by these certain dates. And as part of that, the judge has retained jurisdiction of the matter. It hasn't been completely settled. It has basically been continued. So if there is not compliance, then, and I am required to file a status report with the court. So if there's not compliance, then it would be relisted before the judge that has these proceedings.
okay. Okay.
Just to follow up to your point, I think that people have to understand that the questions come up, why haven't we fined them $1,000 a day or $5,000 a week? We can't do that. Through our solicitor, we're following the correct legal procedures. Now, we're working with a judge, and the judge, we're trying to work things out, but it then becomes the judge's decision, and sometimes you may not agree with the judge's ruling. So that's why we're trying to work things out with the landowner. But once it hits the court, there's not a lot of conversation we can have about it. Both sides present their case, and much like the zoning issues or the Palmer track, it's now before the judicial system in the county, and they then render a decision. Sometimes we win, and sometimes we lose. So we're pressing all the buttons we can at the present time, trying to work within the law. We just can't go out there and rope the place off and close the place down. We'd really be in trouble with that. So we're trying to follow the advice of the solicitor. Now it's in the court system. It has to work its way through that. So we're pressing issue. Dan's doing a good job communicating with the landowner, but once again, he can only do so much. He can write all the letters he wants, but that's as far as it goes. So we are working on it.
Yeah, and so just on the court system too, just so there's understanding, so there's a citation process that we have on our books. And I'm not a lawyer, so I'm just going to summarize, and hopefully they won't from the side table. So we can cite somebody. There's an ability to do the citation of $1,000 a day that then becomes a case in front of the magistrate, which is one sort of court system. That court doesn't have the power to do what the Court of Common Pleas does, and we are now dealing with the Court of Common Pleas, which is where we have some measure of leverage with the judge sort of basically trying to enforce the things we've been trying to enforce without the judge. So there's sort of a you know, the idea behind the citation is, you know, why weren't you citing? Because as Steve said, we've been asked that question, but, you know, at the advice of the solicitor's office, that takes you to the magistrate. So you could, in theory, have fined somebody $1,000 and you might get, but after, you can't do that every day, even though theoretically, like there's a dollar amount where they say, wait a minute, stop, and then it has to go to the Court of Common Pleas. So there's some judicial stuff. And again, it's complicated just because the justice system sort of is designed that particular way. But right now, we're in the Court of Common Pleas, and the key was to not close off the case so that if we don't get the compliance, and again, this board's been very clear, we want to work with people, but we're working to get compliance. At the end of the day, we want zoning, we want compliance from the property, and that's what, you know, Dan and the staff and the solicitor are working towards now.
Okay, I just would like it on the record that, you know, he's, what, 7 days away from the deadline now, something like that? But we continue to hear machinery over there. It's not quiet, you know, it's not bees buzzing. It's machinery crushing things. So I just would like that on the record.
Jane, that's certainly on the record. We certainly appreciate it, and we welcome, as we have said in every meeting, we welcome you to communicate that with with Dan, with the staff. Coming to our meetings, you're always welcome in terms of sharing those comments.
Okay, thank you.
Does anybody else wish to, in the back?
Hi, good evening. Cheryl Brumbaugh, Stony Creek Farms. I've been following and asking for the reports from the Conservation District because I think, Mr. Quigley, you had mentioned that earlier on, months ago, about how it's really important that the government agencies are involved in this case as well. We're referencing the same property that Jane spoke to. So I've been asking for the reports and through Right to Know and getting those and the DEP report. So in summary, the fellow has been out there for the 5th time, and that was on May 12th. I don't know whether Dan was with him or not. The same thing keeps happening. The violations are mentioned. The field order by DEP has been ignored. The NPDES application permit has never been applied for. It's been 6, 7, maybe even 8 months now. I can't keep track. So my question, that has nothing to do with you, and I understand that because you're dealing with the township piece of it. My question, I guess, at this point is, how do you work collaboratively with DEP and Conservation District? Do you not at all? Like, how would we as residents be able to question what they're seeing and doing? Because there's no monetary violations from their end either, just these site visits where it's the same thing every month. He hasn't done this. He hasn't secured the compost sock. He hasn't put this in the right place. He's over on Stony Creek Farm property. So that's my question. How do you work together with this? It seems to be really multifaceted.
So we get all those reports as well. I know I've spoken directly to the enforcement arm of DEP, and while I don't feel comfortable saying exactly what those conversations were because I don't want to mess with their enforcement, I am comfortable in saying they have indicated that when this is, there will be consequences for this, financial consequences. That is what has been indicated to me from DEP.
Okay.
I will say that Dan is making every effort to communicate with them to make sure that we're,
I was just wondering if you could, or how much you could, or so.
it's mostly an informational thing, like we don't have any power with them per se, but we can sort of just stay on top of the matter as much as we can. And they have been good, as Dan has said, in communicating. When they had the site visit, Dan was able to go with them on one of the site visits in particular. So we've certainly expressed wanting to be engaged where we can, but it's more courtesy, I would say, than specific, intergovernmental.
Right, it's just good to hear, though, that is that,
Yeah,
collaboration?
we have an open line of communication with Mike Bogan, who's the Conservation District Inspector, and the DEP. We are actively exchanging information when necessary.
You can understand, though, from looking at these reports, every 6, 8 weeks that he's there, I can't imagine how frustrated this guy must be, that he takes his time and he's serious about it, and, things aren't progressing. But I also wanted to address John, because I did attend the hearing, and I thought that you did very well on the stand. I felt that you were very under attack, like they were attacking you personally, and you did a fantastic job, so I wanted to comment on that tonight, too.
Cheryl, just follow up to your question. Probably when this area of the county was exploding with homes, I sat on the conservation board for maybe 20 years. And when a developer would start developing it without permits or different regulations, the townships would come to the board with the violation notices. We take it under consideration, we review it, and then we work with DEP. So really, the township follow the right procedures. You give it to the conservation board, and once it's in the conservation's hands, it's much like being in the legal system. You give it to the judge, and he rules on it. So really, the Conservation Service and DEP are now running with the ball, I guess, trying to investigate the different violations that's on the property and what permits were issued and what permits weren't issued. And that's a conversation that's going on between those governmental agencies at the present time. So the government never works fast. It's the way, it seems like nothing's being done, but it's a slow process. I guess they dot their I's and cross their T's, and that's pretty much the way the permitting process has been done in Montgomery County for probably the last 40 years I've been involved with it.
Thank you. I didn't see it come up, the DEP, as I think I mentioned at the hearing, and the Conservation District didn't come up at all, so I don't know if the judge is aware of their reports and what they're seeing, but maybe that's happening behind the scenes, and we just have to hope that it is.
Sort of separate. I mean, unfortunately, it's separate. If the matter, we certainly could communicate that as part of testimony, but it doesn't directly, wouldn't have impacted what our case is, if you will, if that makes sense.
That's correct, right?
Yeah.
Because I know they asked John about, well, how do you know if it was an acre, and how do you know how many acres it is, and I thought, well, it tells you right here in the report, it's 6 acres. But poor John. But anyway, thank you, I appreciate it.
Thank you. We appreciate your comments. Does anybody else wish to make public comment before the board? Sir?
Just like to ask a follow-up question.
So
Oh,
I know you've been here, Tim, but
Tim
just,
Creelman, the
Thanks, Tim.
topic again is 1616 Whitehall Road. What happens if he does not comply with the zoning? I assume you issued him a letter with the zoning violations, as you did, I think, in last January. What happens if he doesn't comply?
So the court has retained jurisdiction, so we will ask to go back to court.
So you'll all go back to court?
Correct.
Okay.
And that's about as far as I really can comment on that because it is still open, active litigation.
So everything's back on the table at that point?
Correct.
Okay. Is the goal of the township, I mean, I think we all know, he's turned this property into a construction business. It's a heavy-duty construction business, and he's using this as a base of operations for his construction business. Is it still the goal of the township to get all of that heavy equipment off of that lot to make him stop using that as a basis of construction business?
I can speak to that, too. The answer is yes. Part of the, was not a new notice of violation I issued, just to be clear, was a determination of the property owner has indicated he wants to farm that land. So what I gave him was what I saw that was making me say it was not a farm. Much of that is the presence of large quantities of heavy equipment. So that was addressed in my determination letter.
What did you ask him to do in the determination letter? I mean, what steps does he have to take?
Wendy, is that something I should talk about? Okay, yeah, okay, no, great. So part of it is the removal of the heavy equipment, removal of stockpiles that are not directly farm-related, so stone, things along those lines are not farm, but mulch, wood chips, they would be able to remain. All of the non-agricultural storage that's going on there, so just the random stuff that's there, the asphalt rollers and things like that, they would all have to be removed. So that's the main, I would assume, sticking point with them is we're going to require them, for us to consider that a farm use, we would need the removal of the vast, vast majority of that construction equipment.
How about the metal shipping containers or whatnot that he has?
Shipping containers are accessory structures. We do not regulate in Worcester or any township I've seen the design of what an accessory structure would be. So a garden shed in your backyard, while you may not want a shipping container for a garden shed, you would be allowed to have a shipping container for a garden shed because we do not
So as long
regulate
as you can meet the
design.
setbacks and the various other criteria that gets associated with that.
I assume the shipping containers, or wherever they are being used in connection with the construction business. I mean, if he's prohibited from running a construction business, wouldn't that mean he's got to get those containers out of there?
I would say no, if they are being used for actual storage. If the use is, there's stuff in there for a construction business and they're going in and out of those, taking stuff in and taking stuff out, that's really the problem. But if it's storage, there ultimately is not a lot of enforcement mechanism on what type of things you're allowed to put in an accessory structure, no more than we would tell you what would go in a garden shed that you put on your yard.
I'd just like to make one more comment on fines. I think I testified, I don't know, 2 months ago, 3 months ago. You know, I'm baffled that this has been going on for almost 2 years, and there hasn't been one penny of fines issued. He's done things probably he needed 6 permits for, never got any permits, still doesn't have permits, has never been fined a penny for doing things without a permit. You know, he apparently has zoning violations, never been fined for that. I'm kind of baffled that this has been going on for 2 years and there has not been one penny in fines levied. And, you know, I worked for a neighboring township for 20 years. As soon as this would come to our attention, we would start levying fines. You know, I'll research this some more, but I'm baffled.
So
that
what you need to
there's
understand,
never been a
sir,
penny in fines
you
issued.
need to understand that every township approaches matters differently. And in this case, certainly there's always the ability to go to the district justice and request fines be imposed. But the district justice has no ability they have no authority for injunctive relief. And that has been the path that the board has chosen to take here. We've attempted to work with this property owner to bring the property into compliance. So that was the path that was chosen to go down. You might disagree with that, but that was the path that this board chose to go down. It doesn't mean that certainly if, you know, we are now in court of common pleas, and that is the hammer to get this property into compliance. So fines can be issued. They're often not paid. They are something that can, while they seem to have teeth, they can be ignored and sometimes just don't have the same ability to bring a property into compliance that actually filing an action in court does. So that's the path that this board chose.
Yeah, I mean, philosophically, we try to work with people. Historically, that has been an effective way to resolve these matters. In this particular case, as we've talked about, and it did not get to the outcome the way we wanted to. So we've had to take further action to it. But we appreciate the comments and understand where you're coming from on that, Tim.
Just one more thing.
Sure.
District justices generally will allow you to seize property. If you levy fines and they don't pay the fines,
Not
they
in a
will.
zoning violation, not in this.
Not for
in this
unpaid
instance.
building and permitting fines, they won't let you seize property, any kind of outstanding fines against the township. In my experience, they will allow you to
Again,
seize property.
this is the path that the township chose to take, and that's where we are in an attempt to bring the property into compliance, in an attempt to do so with working with a property owner, trying to really conserve resources, conserve legal fees. This was the process that the board elected to pursue.
Wendy, if I could just say something. When you talk about zoning violations, under the agricultural umbrella, it changed a little bit as far as what's agricultural, what's not agricultural. That becomes the spitting match here that we, the township, is stuck with, trying to define what's a piece of agricultural equipment, what's not. You may think it's not, the neighbor thinks it is. So that's the issue, that it's a tough issue, and it's an ongoing issue. The pieces of equipment on that property, you know, cherry pickers, depends if you have an apple orchard or something. They have different, every farm has different pieces of machinery depending what they do. So under that agriculture umbrella, that's what we're working with. So we have to be very careful in what we do. You can accuse somebody that you may say that's not needed there. Well, it's very easy for someone to prove that that piece of equipment is needed. It's a tough pill to swallow, but that's the law and the legal system we have to follow.
Okay.
Thank you, Tim. We
Thank you.
appreciate your comments. Does anybody else wish to make public comment to the board at this time? Okay, seeing none, we'll move forward. First item up under the official action items is our consent agenda. First and foremost, does anybody wish to remove any items from the consent agenda tonight?
Nope.
Okay, and if somebody would like to make a motion for that, I will entertain it.
I'll make a motion to approve the consent agenda for the April 19 business meeting minutes. There is a correction there for Meadowwood and having 38 units, and there was an error, and it was corrected in the minutes, just for on the record. The treasurer's report and other monthly reports for April 25, and the bill payment of April 25 in the amount of $494,444.17. And Rick, you have signed every check and found everything in order, so I'll make that motion.
And I'll second that.
It's been moved and seconded. Is there any public comment regarding the motion that's on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Motion passes. Next up, under the motion section, we're going to have a motion to approve developer escrow releases. There's going to be, I think there's 3, Dan, and they're all related and connected. Is that correct?
Correct. They're for different phases of the Reserve at Center Square project.
So why don't you just give us a little bit of a, is this going to fall to you to give us a little?
Sure, yeah, I can
overview of what we
definitely
have?
do it. So, you know, our goal is to be as transparent as possible. So, moving forward, in my experience, it's the best, most transparent way to do things is to approve the release of escrows in a public forum rather than internally. I just think it's best practice, and I suggested that to the board, and the board kindly allowed me to make that administrative change. So going forward, when escrows are released, developer escrows will be released, it'll be part of the agenda in the public, and everyone will be able to see and potentially comment on those releases.
So why don't you give the public a quick, how did it get to here? You know, sort of what's taken place internally to make the determination that we're going to release certain escrows, and what we aren't releasing, and sort of who signed off on that so that we...
Sure, absolutely. Luckily, there are some guidelines in place in the municipalities planning code. The engineer our township engineer is the one who receives those requests for escrow releases and then reviews them thoroughly to make sure that the work that they are saying is done is actually completed and up to spec. Per the code, once the engineer makes that determination, it will send notice to the township, and we are then able to release that escrow. That has always been going on. The only difference is now is that last part where we release that escrow is being done in a public forum for transparency's sake.
And then we got 3 here, and John, you can just confirm that you've signed off on these 3 for this particular development in terms of it is appropriate to release those escrows, but it's also, there are many others, if I'm not mistaken, just for those. So in this particular case, it's the Reserve at Center Square. There's several other escrows that are still being held, quite a bit that's still being held, because there are still items that are being addressed with that particular development, correct?
So that is correct. Our inspectors go out when we get a request from the developer, and they go out and actually check the items and the quantities that they are requesting for escrow to be drawn down on. So we go through that and we do a proper review. There's, for phase 1, this is the 9th release. The other phases is the 7th release, and there's still remaining escrow because there's still outstanding items.
Gotcha. So again, this used to be more administrative, but we're now taking the extra step of having the board sort of have involvement to create a motion and approve the release of those particular escrows. So could we do these as one motion, Wendy, or do we need to handle them individually for these three? Okay.
Three.
There's going to be three. You're going to start with and individually.
Make a motion to approve Phase 1 reserve at Center Square, release number 9.
I'll second that motion.
Okay, so it's been moved and seconded. Is there any public comment regarding the motion that's on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Aye. Motion passes.
Motion to approve Phase 2 reserve at Center Square, release number 7.
I'll second that.
It's been moved and seconded. Is there any public comment on the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Motion to approve Phase 3 reserve at Center Square, release number 7.
I'll second that motion.
Again, it has been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Motion passes. All three motions pass, excuse me. So next up, we're going to have a motion to approve Resolution 20-25, start again, 25-11. It's going to be approving LD 2503, 2091 Mohill Road minor lot subdivision. So who wants to tackle this one? John?
I think the applicant's engineer is here, so if we wanted to give a background, I could do it, but it's.
Why don't you do me a favor, sir, and you just come down and have a seat. Tell us who you are. John will do the.
Good evening. My name is Lonnie Manai. I'm with Woodrow & Associates. I'm a land planner. I've been with Woodrow & Associates for 15 years. I'm here to represent the applicant on this minor subdivision application.
Sounds good. John, tell me what it is, why it's minor, and anything else that we should know.
So the applicant proposes a subdivision of an existing 3.42 acre parcel in the R175 residential zoning district to create two lots as follows. Lot 1, a 66,854 square foot lot to contain an existing single-family detached dwelling with 2 sheds, a greenhouse, and a fire pit. Lot 2 will be an 82,141 square foot, 75,338 square foot net flag lot for future development of a single-family detached dwelling. The existing and future proposed dwellings are to be served by private well, water service, and private sanitary sewers disposal on lot systems. Access for these two parcels come off of Mole Hill Drive as a private road.
So my understanding is because it's a private road, there were several houses that were already built. This is sort of the last piece of that puzzle, if I'm not mistaken. Is that correct? And then there's some waivers that are associated with this that sort of make sense because it's a private road and sort of consistency with. Is that also correct? And can you just sort of make a general comment about the waiver requests?
That is correct. The majority of the waivers are in relationship to the road requirements for the township.
Okay. Steve, any questions that you have for this
No.
particular item?
Is this going to just be a two-house subdivision where they're just going to sell the properties, sell the houses?
Well, it's a two-lot subdivision, but there's already an existing dwelling on one of the lots. So it's only going to be one new lot, one new house.
Right, okay. That's all I want to know. Thank you.
The one other waiver was a request to waive the traffic impact fee for one trip as well.
And that's a fee that you have waived in the past in this type of situation when it's determined to be de minimis on a project of this size. You've done that
Right.
previously this year.
Any questions, Lou? No, I don't. Okay, if somebody would like to make a motion, I certainly read through the information. It seems a fairly straightforward situation as it's a private road. That makes it, some of the items sort of,
Just one question. Is this considered a flag lot? You have a private road, you have 2 lots, so one private road will serve 2 properties?
I don't really think it's considered a flag lot. I think it's considered a lot with a reduced frontage on it. And that's a part of the waivers that we're asking for.
Well, there is a flag lot for Lot 2 off of the private street. So it's an access leg, and it meets requirements of that flag lot of the ordinance.
He's hard to hear,
I
but
couldn't quite hear you there, John, if you
Yeah,
could.
so there's actually it's actually a flag lot off of Mole Hill to get access to the back for Lot 2.
Okay.
the only thing that just with life experience with flag lots, and if it's got, as long as the deed's correctly stated,
Yes,
that there's an easement and both parties have right to use the,
and that's something that we will do after this approval.
correct, I'm just clarifying it, that's, I don't have a problem with it, I'm just saying, as long as it's documented in the deed in Montgomery County, that
And
you have neighbors that don't have a conflict with using the property and water rights or whatever.
So Lou, if I can explain, the leg lot is specifically for the back reverse lot, Lot 2, and it's going to access from Mole Hill. So there's no shared access for that. That's only for the driveway for the lot in the back. Where that gray area is.
You're hard to hear, John, but,
So that gray area is only access to the back lot.
and that's an easement?
No, it's part of Lot 2. It's the leg portion of Lot 2.
There's, fine.
And each lot has its own separate driveway.
That is correct.
that's correct. That's correct.
I'm good. Make a motion to approve Resolution 2025-11, approving Lot LD, I guess, Land Development 2025-03, 2991 Mill Hill Road, minor lot subdivision.
I'll second that.
Lot 2, that one.
Been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Aye. Motion passes. Thank you for coming, sir.
Thanks.
Okay. Next up, we got a motion to approve Resolution 2025-12, which is going to be adopting the Montgomery County 2022 Hazard Mitigation Plan as the official hazard mitigation plan for Worcester Township. Dan, if you could just give us a quick overview on this as well.
Sure, yes. So the board has seen this in the past, both in, I believe, '07 and also 2018. The hazard mitigation plan of the township is something we're required to have. It is best practice to have everybody in one county on the same type of hazard mitigation plan for the correct kind of emergency responses, et cetera, et cetera. Importantly, we need to keep it updated because if we do not have an updated hazard mitigation plan, it could jeopardize our access to PEMA and FEMA funds if something, some sort of natural or man-made disaster were to hit. A line of tornadoes takes out a bunch of roofs off a subdivision, et cetera, et cetera. The body of it's very similar. There are very few changes. There are certainly no substantial changes. This is more of a administrative, just making sure we're keeping up to date with our hazard mitigation plan and that we continue to be eligible for federal and state funding in case of an emergency.
So procedurally, this is something we want to have in place that if ever we have a need for that sort of funding, it certainly seems to make sense to do that.
Correct.
Sounds good. Any questions from either side of the board?
Nope.
Okay, then if you want to make a motion, Lou?
Make a motion to approve Resolution 2025-12, adopting the Montgomery County 2022 Hazard Mitigation Plan as the official hazard mitigation plan for Worcester Township.
It's been moved and seconded. Is there any public comment regarding the motion on the floor? Bob?
Bob Andor in Worcester. Not that I have no idea if this document is 2 pages, 2,000 pages, 20,000 pages. Not sure I would even read it, but I suspect that none of you have read it either. And my suggestion would be that you provide a link for something that you're adopting so that people could find that document and read it if they were so inclined to do so. I didn't try to peruse or even locate where that is, but I did note that it's not attached or part of.
I think that's reasonable. Certainly, that makes sense. Thank you, Bob.
Is that on the county website? Would that be on the county website?
It is. I'm happy to post a link on our website. It is 330 pages, so
Either way.
get yourself a cup of coffee and we'll get you a link and everybody can have some good reading.
Publicly accessible is what you're stating. So
Yes, sir.
It's on a website, and
But we should be
I
able to
will- I
point them to
will-
it.
I'll post a link under emergency management, so that is up, so everyone can see what that hazard mitigation plan is.
Fair enough. Is there any additional public comment regarding the motion that's on the floor? Seeing none, I'll call the question. All those in favor? Aye. Motion passes. Next up is going to be a motion to advertise for the 2025 road improvement bid. So we're not voting on the bids, we're voting to advertise the bid, correct? Is there anything we should know uniquely about this year's road program relative to past years, John?
It's about the same. The base bids can consist of 10 roads within the township with an add alternate of an additional 3 roads, depending on what the pricing is when it comes in.
Have we seen any bids in other municipalities coming in on the road program? We're always curious. Certainly, the numbers have been all over the place the last few years.
Yeah, sure. We prepare an estimate with the quantities that are provided by the township, and they're in line with the previous years. You know, there's some increase, but it's not dramatic.
Okay. Fair enough.
John, question. Every time we go through this, there's always a question about the price of fuel oil related to the asphalt. You think there's any time in waiting on the road program with the price of fuel? It's not going to go down with the price being higher now? Is there any time frame in other projects you've worked on that's been delayed due to the economic trends?
So we're a little later. I think we're about a month later than we have been in the past for road programs. If we wait any longer, I think it's going to be a time crunch to get it done by the end of the year.
Okay, thank you.
just the one,
No. So,
number of roads, correct?
John, could you just, do you have the list of the roads? Yeah. Lou is asking. I think it's predominantly Sunnybrook Estates, if I'm not mistaken, but
That is correct. But I'll read the list of the roads. Include the following roads or portions of: it's Crestline Drive, Hillside Circle, Long Meadow Road, Preble Circle, Quail Run, Stony Creek Run, Fire Road, Overhill Road, and East Mount Kirk Avenue. That's the base bid. And the add alternate will be Creekside Drive, Pondview Drive, and Spring Creek Road.
so anybody who doesn't know, that's along North Wales Road. So last year we did what was the milestone development largely. That was the bulk of the program. This year it's Sunnybrook, plus there's some further down on North Wales. Those are the additional roads there as well, which had been in the queue for several years.
Yeah.
One other question. Compared to last year's list, are these roads the ones that were down lower in the level, or there's some other roads that really deteriorated since last year's program?
It's my understanding that the Public Works Director grades the roads every year and makes that determination of the worst roads that gets done paved from that yearly program.
Okay, thank you.
I can speak for Sunnybrook, Steve. It's the original road, so it's 25 years on those particular roads that have held up well, but it's at 25 years at this point for the replacement of those.
Never ends, does it?
Never ends.
Never ends. And Mount Kirk, and I thank Dan for pursuing that. Mount Kirk needs repair, because it's a busy intersection. So I'll make a motion that we make a motion to approve advertising for the 2025 road improvement bid.
I'll second that.
It's been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Motion passes. Next up, we have a public hearing. Folks who have attended, which I think is everybody, of late, we have the Comcast franchise agreement. We've talked about this a couple of times over the last few months, and tonight is sort of the official step of a public hearing so that we can get everything sort of on the record appropriately and then make a voting decision regarding accepting that. So Wendy, I'm going to hand it over to you to handle the mechanics of the public hearing.
Sure thing. So as you indicated, this is a public hearing with regard to an ordinance that will authorize execution of the cable franchise agreement with Comcast. And the township, because the cable franchise agreement process is really sort of a niche area, the township had engaged the Cohen Law Group to handle the negotiation of the terms of the franchise agreement renewal. So just to start out with, because this is a public hearing, I do, regarding an ordinance, I do have just a few, what we'll call board exhibits. So Exhibit B1 is just the meeting minutes, the draft meeting minutes from last month's April 16th meeting where the board authorized advertisement of the ordinance. Exhibit B2 is the legal notice, which is legal notice that was published with regard to the proposed ordinance. Exhibit B3 is transmittal of the ordinance to the Montgomery County Law Library, which is required for any ordinance under the second-class township code. Exhibit B4 is the affidavit of publication that the legal notice was advertised in the Times Herald on May 7th, 2025. And then lastly, Exhibit B5 is the ordinance itself. It's ordinance number 2025-12, an ordinance of Worcester Township authorizing execution of a cable franchise agreement between the township and Comcast of Pennsylvania, LLC. So I'll just summarize briefly the highlights of the agreement. Cable franchise fees are payable to Comcast to use the township's rights-of-way to operate the cable system. Comcast is under the terms of the proposed renewal. Comcast will be paying a franchise fee of 5%, which is the maximum percentage allowable under federal law, and that is the same amount that was paid under the prior agreement. Those franchise fees are payable quarterly. The definition of gross revenues set forth in the agreement is as broad as possible so that there are items captured under the fees for on-demand video, future technologies, that type of thing. So the definition is as broad as is possible. The term of the agreement is a 10-year term, and from the township's perspective, the Cohen Group always tries to negotiate the shortest term, and although 10 years does sound like a relatively long term in the world of cable franchise agreements, that is in fact a short term, and that's what Comcast is willing to accept. There are reporting and audit provisions in the agreement to ensure accountability. The agreement is non-exclusive so that the township can enter into an agreement with Verizon as well. There's also, the township does have the right to request the use of the public educational and governmental program, which is a cable channel that the township could use if they so chose. I believe it's currently used by the school district. There's also penalties in the agreement if there were any underpayments by Comcast of the franchise fees, if an audit was done and it was found that there was any underpayments. And then in the event that there was any breach of the agreement, there is a clause for liquidated damages in the amount of $250 per day in the event that Comcast should breach the agreement. So we have it on information from the Cohen Group. They feel that this is a good agreement for the township, and they are recommending its approval. So with that, again, there is the requirement that it be adopted by ordinance.
Okay,
And
let's
that's it.
start with if there are any questions on the board. Steve, if you have any questions regarding the agreement?
Yes, Wendy. Question regarding, I'm sure Comcast, much like Verizon and Pico, have the lines along the roads, correct? When a tree falls down and is disrupting the traffic flow in the township, it's on the wires, whose responsibility is it to, if it's not the landowner, it's an act of God, it falls on the wires, that and the tree's sort of going onto the road, is it up to the utilities or the cable companies to take care of their wires, or they just let it break, then they go out and fix them themselves?
Go ahead, Dan.
That's a great question. It is always a hot topic at our consortium meetings. Pico obviously is responsible for their wires because they're charged, they're electrified. They have obviously have to take care of it. Comcast and Verizon have taken the longtime stance that it is the owner of the property that should be keeping their trees out of their wires. If you recall, there was a tree that was on Valley Forge Road, right by your farm, that was ultimately, I took that all the way up to executive relations, the state representative. Ultimately, it was the church's responsibility to take care of that tree.
Well, Dan, I guess the old thing, what came first, the chicken or the egg? The tree was there before the wire.
Very fair point.
That's
I
your
agree with you.
problem. I mean, I understand the situation, but if I'm the landowner and I had my tree was planted, you decided to put the wire there to make money. I mean,
I used that exact argument with the executive relations people at Verizon in that case, and they didn't buy my argument. The only person that could regulate that would be the PUC, the Public Utilities Commission. They are getting a lot of lobbying from those organizations to be very, very sure that they don't make that rule a reality. I agree with you. It should be something they are responsible for, but legally, as it stands now, it is technically the property owner's responsibility.
but it goes back to I think the legal case is, Wendy, if a tree's on my property and falls on the fence, isn't it property owner on the other side's responsibility to clean it up?
That's an argument that gets made many times, Steve,
Yeah,
and it's, there's arguments on both sides there. There's an
Right.
argument that it was your tree and you failed to maintain it, that it perhaps, so it's not always clear cut. And it's one of those things that becomes, unfortunately, landowner disputes that.
Right, and once again, it's a state road, it's not our problem to fix it, but being custodians of the township, safety of the people, residents of the township, we went and fixed the problem. But, is now the time to hold Comcast, have an agreement with Comcast, if, now's the time, hey, you want to run wires to our township and provide service? There's a price to pay for that, and it's the maintenance of your lines if there's a problem. I guess I'm pissing in the fan, Dan, probably.
Unfortunately, I think that's a provision that we're not going to be able to work into the agreement.
Well, it's just one of those things you try to negotiate, but it's an issue. Once again, you want to do business in the township, but you just want to run the wires, but you're not responsible for anything if the wires come down that impact our residents, that's all.
And I've reiterated my administrative concerns about that to our state representatives. If the board would ever want me to relay more official concerns about that from the board themselves, I certainly would be able and willing to do that.
Okay, thank you.
I don't have any specific questions. I do just want to make a comment relative to the previous meeting. We talked about some of the economics. So historically, we've run around 50,000 a quarter, around 200,000 a year in franchise fees. Is that the correct number, Dan? Does that sound?
Approximately, yes.
Again, one of the things with franchise fees, certainly there's streaming services and things that might impact what the Comcast cable is actually delivering, but historically it's been about $200,000 a year as a revenue source there. So obviously there is some economic benefit to deal with some of the issues of maintenance, but just for the record, I want that number on there, but no questions. Lou, any questions from you?
Rick, I guess my comments were centered around when a developer wants to come into the township and build homes, you got to fix the road, you got to do this, you have to give them so much open space, and we ever look at holding these franchise companies with some kind of fee attached to it for maintenance?
That's a fair point.
Why should we take the money out of our pocket that we're making our profit from letting run the wires? Maybe some kind of maintenance agreement with the companies.
Fair point.
Thank you.
Ready?
Yes, sir.
I got a story for you. So let's talk about Comcast. Every day for the past 18 months or better, I drove by this broken pole on Church and Germantown Pike. I witnessed the accident. I was there with the fire department when they were directing traffic. That pole has been broken and leaning into that intersection. And I have Verizon contacts, I've dealt, and Dan has tried, and I have Pico guys that'll pull the pole. Everybody keeps pointing their finger at Comcast, and I would like something in the agreement that we need a actual human person to contact them for maintenance. Because the only thing that's stopping Verizon and Pico from pulling that pole is Comcast to move that wire from the broken pole to the new pole for 18 months. And apparently Comcast seems to be slow. So I contacted Matt Bradford's office. I'm getting action. I don't know if they're getting anywhere, but Comcast doesn't like to do the maintenance. So I would like, if they want an agreement with Worcester, I want a connection and a human person to talk to say, when there is an accident, within so many hours or so many days or something, let's not stare at broken poles for 2 years. And this has been going on for a long time. So, is that a possibility? I don't know. I would love it to be, because Dan has gone nowhere with this, right?
It is certainly within the rights of the board to not pass this and give me instruction to pass along to Cohen to say that these are things we want addressed as part of our agreement. That is your right as the board.
So I can just tell you that there are currently some customer service standards in the agreement. I'm not sure that they necessarily apply to what we're talking about here. There are more customer service standards that Comcast is required to follow with respect to customer complaints. But one of the things is that there are time limits for commencing installation, service interruption, and repair work. Now, again, that seems to probably apply to folks who have Comcast, that are subscribers to Comcast. I'm not sure that any of these service requirements would fall under the topic that you're discussing. So, but it's, it certainly never hurts to go back and ask.
I believe they want our money, they want our service, they want our residents. I just want proper service to the residents, and I believe we actually have a little leverage. If they want our money, I just want you to own up to your service and move a wire on a pole, that's all.
So,
It's not asking that much. I mean,
no, so let's ask the question, let me ask, in terms of the timing on us signing off or agreeing to sign this, does it jeopardize any agreement that's in place currently? Is there any time constraint that would cause issue to that? I don't have any issue asking those questions either. If there's,
As far as I know, if we delay it we're talking about another month, I don't think that would.
okay,
Frankly, your current agreement is with Comcast, I believe, is technically expired, so you're sort of going on a month-to-month basis.
That's correct.
So
Cohen,
if we were to go back, and I think that we could just, I don't want to have to re-advertise the ordinance. If we just said, okay, you're going to defer any action, but keep this public hearing, basically continue it, so we don't have to re-advertise.
that's fine.
I think that would be appropriate.
I'm fine to do that. I don't have an issue with that.
Mr. Chairman, once again, anybody that does business in the township, there's fees to pay. We have road impact fees, this fee, that fee. Why don't these cable people who, and certainly, every time I look at my cable bill, it's not going down. I think it goes up rather quickly. So it's not that they're a nonprofit organization that we're trying to help out.
That's right.
I think that someone needs to be accountable, as Mr. Betts said, as far as service and things, that now's the time we renegotiate the contract. We need to start looking at these things. So I'd make a motion that we table it. And
Sure, so what action do we need to do to continue the hearing, and we'll go back and we'll ask them.
I think you can just, as Mr. Quigley said, just table any action, and
Okay.
we'll leave the public hearing that we have advertised,
Fair enough.
continue it, and return to it next month.
Okay, perfect. So folks, there's not going to be public comment specifically to that, but we're leaving the hearing open. We're going to go back and ask a couple questions, see if we can get a couple of adjustments to satisfy the maintenance requirement that Supervisor Betts is asking about, and it'll be on next month's agenda to continue.
there's no representative from Comcast here? Nobody? Guess not.
Not that we're aware of.
Okay.
I don't think so. Okay,
So moved.
so I guess we're good there. We said, all right. Fair enough. Next up, we have other business. Does anybody have any other business they wish to bring before the board tonight? I do not. Okay, then last up, we got public comment. Does anybody wish to make final public comment for the board this evening? Bob?
Bob Andor, Worcester. First, you had mentioned that the audit is complete and that you have the desire to have the auditor here as part of a work session. Do you have any inkling on when you might like that to happen?
So historically, it's been July, it's been the calendar, but ultimately, I'm going to, Dan?
We do have a scheduled work session in June, and we have scheduled that for June, so that will be your work session in June.
That'll be June, Bob. I stand corrected.
Great, thank you. The second is a question that I've raised before, and I'll raise it yet again. In terms of payment of the bills and the application of those accounts. So my question is there any mechanism by which a resident can look at the bills that you've paid or proposing to pay currently or past, and the budgetary allocations that you have as part of your work document? None of those numbers ever align. So is there a mechanism, or is the mechanism for somebody to file a right to know asking for every month for the breakdown of how those budget activities are done?
So the mechanism of the right to know is there. That is certainly there. You don't have to answer tonight, Dan, but certainly that's been an open question, and we'd like to at least be able to respond that we can't, or how we can, or when we can on that particular item. So I don't have a ready answer for that, Bob, but I know it's been asked. I know that we've been looking. If you want to comment?
I do have an answer.
Okay.
Yeah, the answer is yes. We can pull individual line item reports that show the ins and out for each line item. That's this quick and easy answer is yes, we can do that. It would be, there's a significant number of line items, so it's not something we generally include with the packet, but it is something that we can run reports off of our financial software to do.
Okay.
And what is the proper mechanism? Filing a right to know, or?
So right now, it's right to know, and we'll have to decide whether we can just get it published up as sort of part of the bill pay process, or if it stays right to know.
Okay, so that's just how it is until you change it. So,
Correct.
which is fine. And lastly, something I've been asking about for in excess of 2.5 years. What is the status on the lighted signage ordinance? And is the township going to do anything with that?
So you want to tackle that one as well? I know that it's got to go to planning.
Yes, I have a draft of a sign ordinance which includes addressing digital and lighted signage. It will be in front of the Planning Commission for review as soon as our accessory structures draft review is complete.
Okay.
That has taken some time, but we are
Okay.
hopefully coming toward the end of that.
The reason I say that is I've raised this question or commented on it time and time again, is we currently have an ordinance that prohibits internally illuminated signs. The township is doing nothing about that, and you have a sitting supervisor who has a lighted sign, internally illuminated, that is illuminated every day, in violation of your own ordinances.
Some days, not every day, because we're closed some days.
Every day I go by, Steve, it is. So,
That's a general statement, it's not every day.
okay, I stand corrected. Every day I go by, it's lighted. If I need to show that it's lit every day, then, I can do that. But the issue is, I'm aware of at least 2 other businesses that have had to turn their signs off because they're following the rules. And we now, so if you're not going to follow the rules, please abandon that ordinance and allow anybody who wishes to internally illuminate a sign to do so without running the risk that they're running afoul of the township laws. And if you intend to follow the rules, then please do so for all of the township residents, including sitting supervisor, who should be following the rules, if not having a higher standard that he would be following. I've asked time and time again. And for the record, I am in favor of illuminated signs. I sit on the Planning Commission. I would sign off on that immediately. If you want to do it piecemeal, however you wish to do it. What I don't understand is how you just turn a blind eye, or the administration is collectively turning a blind eye because it is a sitting supervisor. But, and for the record, Steve, you've said that before. And then you have specifically said that you don't control it, you didn't do it, you didn't install the sign, you didn't modify the sign, all of those things. So if you want to take accountability for it, please do so. And understand, I'm not trying to prohibit you from having a lighted sign, but the law is the law, and you should have to follow it just like everybody else.
Thanks for your comments, Bob.
Thank you.
Does anybody else wish to make public comment before the board tonight? Seeing none, then motion to adjourn. Thank you all for coming.